So viewers, once again, we are here with my great old friend Rehman Mian, who has been practicing in the UK for over 21 years like me, but he chose to practice continuing as barrister as opposed to me, as I chose to practice as solicitor. So practically I'm non-practicing barrister and practicing solicitor at the moment. So he has been at the moment working with chambers that is called Great James Street Chambers, and you have been doing a lot of work, whether it is immigration or civil litigation, whether it is criminal matters. So we have been keeping you busy, and so many other solicitor firms are after you, and very often they don't get you because you're very busy. So thank you very much for joining us in this live session. It's a great pleasure to have you here. And our format is that we do get questions live, and we will try to answer them. We have some inquiries already with us. We will try to answer them, and we will try to speak about the common problems our community facing here, so how we can handle them. So first of all, again, welcome to the show, and it is really a pleasure to have you here.
Well, the pleasure is mine. Perhaps I can firstly extend my greetings to the viewers who have joined us here on Facebook Live, and of course, thank you to you for inviting me. So my salams to our viewers, and I should at this stage say that I've known Mr. Waheed for a number of years now, and I have worked very closely with Mr. Waheed and his team, and I have always found the services provided by your team and yourself to be excellent. I've enjoyed working closely over the past 20 years with you and your firm, and it's an absolute pleasure and an honor to be able to come here. So thank you very much for inviting me.
You're welcome. So I think we should start with the questions we already have, and those questions are in relation to immigration. If I need expert opinion, we will invite Mr. Mian to comment on that as well. So first question we have is, I have ILR in UK. How long can I stay outside UK, and what happens if I'm staying abroad and want to come back later? Well, it's a simple question and common knowledge that if you have got ILR in the UK, you can stay outside the UK, but the maximum time you can stay outside the UK in one go is 2 years. If you stay over 2 years, and on your return, if you don't have reasonable excuse for that, for example, some people, they stay outside UK for medical reasons, and you have credible evidence to confirm that, then very, very likely they will allow you. It's a discretionary matter, but otherwise they can cancel, curtail your leave, and you will have to start from scratch again. So keep in mind, it's 2 years, not more than that. But if you do come later on and there are compassionate grounds, then they will consider that. The other question is that I'm a British citizen since 2015, but now living in Pakistan with no family. My son was born recently. What are his options for UK? Well, if you are British national, and any children who are born after your nationality, anywhere in the world, they can straight away claim British passport. They don't have to go through the procedure of nationality. They are by birth British national. So that is fine. There is a technical issue that how did you get your British nationality? If it was by descent, then you cannot pass on. But otherwise, you can pass on your nationality to your children. Doesn't matter where they are born. So he can go for British passport straight away. Another question, I'm a mother of a child whose father is British by naturalization. His divorce process is not finalized yet, but he also married me. What are options for me and my son who is yet to apply for his passport? Okay, so I believe that you are living with him as partner. So if you're living with him as partner and you have been living together for over 2 years, then still you can make application. Whilst you are in the UK, they will consider, and most likely they refuse the applications by saying that you can go back and continue your family life in your country of origin, because at the time of living together, you knew that your status is not settled status, so you should have known the consequences. However, there are two exceptions to it. One, if you can show that it will be extraordinary hardship for you or insurmountable obstacles, then you will be allowed to stay here. You will be granted visa. This is most difficult part of it. But the easiest part is if there is a child who is already British or settled here or 7 years old, he has lived in the UK for 7 years, then your case will be considered in the UK and you will be granted visa under 10-year root category. And this is again a common misconception which people don't know. Once they get married to a British person, they think that they are in 5-year category, but actually they are not. If they were not legal at the time of making this application, they fall under 10-year category. However, once you have given this 2.5 years visa, you can always go back to Home Office and transfer your 10-year category to 5 years, because now you are legal and you can go for 5-year route anyway, where the requirements are 18,600, or if they are children, then accordingly, and your English requirement. There are more questions, and I believe immigration questions are coming up, but we also try to involve our guest today here, and there are some questions we have received. And the most common question I'm getting here is, for an example, there's a family setup and they have been living together, and a time comes when they decide to buy a house, and they have bought this house on the eldest child name because he was working. However, they did put all of them did chip in the deposit, and they have been living together, so they were member of the same household. But after a few years, 10 years, 20 years, when mortgage is near to end, um, this gentleman comes up and he says, hang on a minute, I paid for it, it's my property, you have nothing to do with it. Similarly, like it happens in back home countries when people buy properties on their relatives' names and they say, thank you very much, goodbye. So what options they have if it happens to them?
Well, that's a very good question, and the reason for that is this. It's such a commonplace occurrence within the community. In fact, it's actually rife. And there are a number of reasons why it is that in families, extended families, the actual setup of the home where perhaps 3 generations are residing, it is elected that one person will be the nominee or the person whose name is registered at the land registry, HM land registry, in order to be able to purchase and acquire that particular property. Yes. For a number of practical reasons, income, mortgage, whatever it is. But the reality is that the beneficial interest is actually, and intended to be actually, belonging to more than what that particular person. So sometimes in patriarchal societies, we see that it's beneficially to be owed by the father as well as the siblings of the individual with, whose name the actual property is eventually purchased in. So the law, although it's a starting point, the land registry title deeds, the office copies, although that's a starting point, there is a legitimate further inquiry to be had upon a claim by a third party, i.e. a sibling or a father even, or even a mother or sister, anybody like that, who actually says, well, the common intention was that we or I or whoever else the case may be was also intended to be an owner, a beneficial owner of a particular stake in that property, a particular percentage. Or
even though they don't have any documentary evidence to support their claim.
The law does not require corroboration, although evidence supports an assertion. So, for example, where you have a scenario where, and I'll make it quite simple, 2 brothers are residing at a property.
Yes.
The property is purchased in the name of one of the brothers. The younger brother then says, well, actually, I also have a beneficial interest in this property because at the time of purchase, the common intention was that we would both be residing there. Now, normally, in order to corroborate that claim, that assertion, one would provide, for example, any sort of financial evidence of financial contributions towards the deposit, the mortgage, the utilities, and so on and so forth. But invariably, we see that transactions are not always, especially many years ago, transactions are not always online or evidence, or there's not what we call an audit trail. So you may not be able to see that the funds which actually discharged the mortgage payments originated from a particular account. So when brother A pays the mortgage from his account, an audit trail would demonstrate that brother B had actually paid from his account to brother A's account, which then went on to pay the mortgage to the mortgage company, the actual repayment or installment or whatever the case may be, if it's on an interest only or whatever. And that's why it is often the case that the more corroborative evidence there is, that will shed light on and support the assertion that the beneficial interest or the common intention was that another person had a stake. Same goes with a deposit, for example. But the fact is that for whatever reason, very often we see cases which we have to find ourselves advocating in court, where people do not have that audit trail, where the deposit, part of that deposit contribution was paid in cash to a third party who then paid it on to somebody else. There may be a number of reasons for that. And therefore, the evidential burden which requires to be discharged by the person making the assertion makes it a little bit more trickier. And therefore, that evidence needs to be coupled, or limited evidence needs to be coupled with more credible, or absolutely credible, evidence, oral evidence, and possibly even further witnesses, and so on and so forth, so the judge, the independent arbiter of fact, deciding the issue before them as to the likelihood of there being a beneficial interest by that claimed party, will look at the case in the round and arrive at a conclusion, taking into account all the evidence, written, oral, any other corroborative evidence, and arriving at a decision as to whether it is more likely than not that one party is telling the truth or is being able to demonstrate that their rights are correct and as intended than the others. So that's in relation to, we were giving an example based on the premise of, say, siblings. But if I could just labor this a little bit more, because often we find the case that it's not siblings, but it's two people who are in a relationship where there is a marriage recognized under English law. So, for example, not just a marriage which was undertaken in the United Kingdom, in this jurisdiction that the courts would seize, but also even if it was abroad, Pakistan, Bangladesh, or anywhere else in the world for that matter, if that marriage in that jurisdiction is recognized by the law of England and Wales, because that's the jurisdiction that we operate in here, then the matrimonial home rights kick in, the Matrimonial Causes Act kicks in, if I can use that phrase, and a number of other associated provisions and principles come into play. But you often have the case in the United Kingdom particularly, where couples have an Islamic union, a nikah as we call it. They do not formalize their relationship by way of a civil registration or a civil partnership, if that's the case. And then further down the line, it transpires that following on from a deterioration in that relationship, a party whose name is not on the deeds, so sometimes, for example, the wife, if the property is in the name of the husband, but the wife is not recognized as a wife in English law, the relationship deteriorates, then the question is, does that wife, in inverted commas, who is not recognized in English law as a spouse, does she have any rights and interests in that property beneficially? And there is a particular interesting evolving area of law here, because what seems to happen is that very recently we've had case law which suggests that a union, a sort of a marriage can be nullified, or in fact there can be beneficial interest under talata, and so on and so forth, the trustees of land and report. Basically, what you see there is that a lot of different principles of law are applied. So for the benefit of our viewers who have kindly joined us, and those who may see this later, the fact that somebody is named on the deed is only a starting point, conclusive to what is declared in that TR1 form, because that effectively is a declaration of the interest of the ultimate owner. But then that does not mean it's game, set and match, and that nobody else can intervene or raise an assertion of a beneficial interest. So if anybody does feel that they do have a beneficial interest or has a stake in a property, an interest, or whatever they'd like to call it, they should not believe that there is no hope for them, because there is.
Great. It's a very detailed explanation you have given. So just to add on that, the court will obviously also look into the sources and resources of that particular person who's claiming to be the legal owner, that, okay, when you paid the deposit, what was your source of income? Because he may have the situation where he will not be able to prove that, and then he will have to come to the terms, yes, I did borrow from somewhere. So that will go to the benefit of those people who are trying to claim the beneficial interest in that as well. So his source of income, his circumstances will be very relevant there as well.
Not necessarily. And the reason for that is this. If, for example, the person who has paid the deposits, the party B, whose name the property is not on, can demonstrate that an amount of money was paid over. If, for example, when you have disclosure, because the civil procedure rules are quite broad and there are various provisions, so in a claim such as this, which would commence at a particular stage, if it's defended, then there will be various prerequisites to trial, including disclosure. You may have pre-action disclosure, you may have disclosure within the course of the proceedings through directions given by the judge who's dealing with the case management, for example. What will happen then is that once you have disclosure, once you have a disclosure of documents and possibly even inspection, this may include the conveyancing file. Once you look at the conveyancing file, the kind of documents that will be important include, for example, a completion statement. And in a completion statement, a solicitor will usually detail where the funds came from. So a completion statement provided to a purchaser will include a breakdown of this is where the deposit came from, and this is the date it came, and this is the amount of money that came, and so on and so forth. Now, if, for example, party B, who, for the purposes of clarification, is the person who's asserting a right because his name or her name is not on the deeds, if they can say, well, you see that amount on that given date, that is the amount that I paid, or came through me, or came on my behalf. So if they can identify that entry, for example, that's well, actually 20,000 of the global deposit amount was paid for by me, then the burden sort of shifts, doesn't it? Because the person who's denying that will have to be able to disclose their evidence to say, well, actually, no, that amount, which party B is alleging came from them, actually came from me. Here is my bank statement, and you can see the audit trail of that money coming out of my account and going into the scalp. If you're lucky, there may even be a reference number saying the deposit or purchase or the address. It may not, but it may well be. So the more meticulous and forensic that exercise is, the more beneficial it is for the person who's asserting that. So there is a disclosure process to take place. It is often the case, and I'll just delve on that issue a little bit, where some people may not be able to account for the provenance, as we call it, of the funds that they say that they presented as part of the deposit, to use that example. My particular view on that is that it doesn't matter. There is no legal requirement on an individual to incriminate themselves, for example, if they are unable to account for monies which the provenance of which they may be unclear about. They certainly don't need to incriminate themselves. They may not be may not be able to give a breakdown, but it doesn't matter, because once they say this is the entry, this is the amount I paid on this date or thereabouts, then the other side must be able to say, no, I actually paid that. And if they can't, then the argument of party A dilutes.
Thank you very much. Once again, very detailed information on that. We have further questions on immigration, so I'll take a few questions there. We have a question where it says, I have completed my 10 years legal stay in the UK, but could not apply for ILR at that time. Can I apply now? Well, yes, as soon as you complete your 10 years legally in the UK continuously without any gap, you can apply for ILR, and if you want to apply after 12 years, 30 years, definitely you can. So as long as you have spent 10 years continuously with you. Another question is, I'm an EA family member. I'm refused settlement, although I'm in UK for the last 6 years. They refused me saying I have not completed 5 years from my marriage. Please advise. Um, yes, if you see, if it is the EEA case where you obtained your initial resident permit because of marriage, then you have to complete your 5 years from the date of marriage, not necessarily from the date of visa. So there are circumstances where you have obtained visa not because of marriage but because of partnership living together for 2 years, and on those basis you, as a durable relationship, as a partner, you were granted 5 years visa. So in those circumstances, you will have to wait until 5 years from the date of visa. But yes, you can still apply under these new settled and pre-settled regulations. You should apply if you have been living together for 5 years and your sponsor or spouse has been exercising treaty rights for 5 years, or if he's not or she's not, then you have been working for that long, you may well be able to apply for that. But on the other hand, if you have lived together for 6 years and the visa was granted in between, you can directly go for nationality as well. There is a provision for that as well. But if there's a particular question you want to ask, please send us an email, which is info@m-rsolicitors.uk. Any question arisen from the discussions we had on this property issue, any litigation matter, again, you can send us an email and we will respond back to you, or you can call us to make an appointment on 0208-518-1956. Further question we have is, can I apply for benefits when I'm not entitled for public funds due to current pandemic? Will it affect my status in future? It really depends in what category your visa was granted. And I give you two scenarios only for the time being. One is if you were granted leave to remain under 10-year category, and that is 2.5 years visa, and your visa status, your card, your residence permit says no recourse to public fund. Definitely you can ask the Home Office to change that because of this pandemic situation. If you can prove and confirm that you are suffering and you are in destitute situation, definitely you can get it changed and you can go for benefits. If you are on spouse visa, for an example, where there is a requirement to continue with £18,600, then it will affect your status later on. However, again, the office has clearly mentioned that we will see and decide case-to-case basis. So if the circumstances are very compassionate, still you can make an application even after claiming benefits, and they will consider in what circumstances you have to go for benefits. So there is no strictly no, but it depends on your personal circumstances, as the office has suggested. I can't pass English test. Another question we have. My daughter cannot do it as well while she's turning 18 soon. We are in Pakistan while my husband is in UK. Can we apply? What are the chances? Okay, well, if at the time of application the child is still under 18, a minor, then she does not have to pass any English test. But if she is over 18, then first of all, she may come out of the spouse visa category anyway because she is independent. She will not be considered as dependent anyway, so she will have to move another category. So if the application, and I would encourage you to make an application before she turns 18, if the wife cannot pass English test, then there has to be a reason for that. If there are some medical compassion reasons, people do provide medical reasons that why they cannot do the English test, they take English test, then there are exemptions and still they can get visa on those bases. Otherwise, you will have to apply in the human rights categories, and then it will be a discussion to whether to grant you or not. So I'll turn back to you, and there are more questions. People would like to know, this pandemic situation has created so many problems as well, domestic-wise, and you may have, you're well aware, obviously, that domestic problems have arisen, and there are so many injunctions coming up, non-molestation orders, domestic violence. And there is another aspect of it which we don't call as entity relief. Can you elaborate on that ancillary relief, what it is, what kind of orders we can get under that?
Well, yes, of course. You raised two points there, very important points. Firstly, you're quite right to say that very sadly, the circumstances at the moment, because of COVID situation, has meant that the domestic situations are sometimes volatile. And what that means is that you find yourself in a position where things are not as rosy as they could be at home. And that's obviously a very sad situation, particularly if there are children involved and if there is an impact in relation to that. And that is why the non-molestation that's available, the non-molestation orders that are available, the prohibited steps orders that are available, the Family Law Act 1996 provisions, and then of course in relation to children, you have the Children Act 1989 provisions. There are all sorts of things to consider. And then parking that aside for a moment, if we then move on very swiftly to say that in the event that a relationship irretrievably breaks down, and in the event that there are assets which require distribution between the parties, then one may find themselves in a position as to what is fair, what is needed, what is something that is going to be sufficient, not just for the parties themselves, but also for the needs of the children as well. So these are things that need to be taken care of. There are a number of different factors which judges look at. We call them the Section 25 considerations. The judges will look primarily at the needs of the parties, including the children, and the judges then look at what else is available. So, for example, if there is the first is to let the parties know in no uncertain terms what their legal positions are or are likely to be from the perspective of the judge at the FDR, the Financial Dispute Resolution Hearing. The second is to understand what the costs are. There's something called a Form H. And in the Form H, both parties would be stipulating their costs thus far, and then a judge would be able to assess and say, taking account of what's already been funded and what is likely to be the cost to be incurred for the substantive matter if it went to a final trial, whether or not it is going to be proportionate, whether the parties really need to take a concerted view as to whether or not it is essentially worth it to be able to go to a final trial, or whether they should both make compromises and come to a decision which will be the interests of both parties. Those are the kinds of things that the FDR is intended to achieve. In the event that the parties are still too far apart and the matter requires further determination by way of a final hearing, then that would be the case. And I should, for the purposes of completion, continue to say that, again, it is not just property or vehicles or paintings or whatever the case may be, but other things like pensions, for example. These are matters which are also to be considered as part of what we call the pot. So the distribution of pensions and that sort of thing. So there are a number of different pieces of the jigsaw which a judge will take into account when arriving at the overall picture as to whether or not what is claimed by either party is likely to be a fair distribution of the assets. And that is why these sorts of matters, particularly if they involve assets beyond just, say, a single family home, these are matters which most certainly people should take legal advice on, even if at a very limited level, on a limited basis rather, because the consequences can, if anything can be disproportionate, the consequences can. And it can be unfair. That's not something that they wish to see. So ancillary relief, the financial aspect of it, as we say, something that is very important, should be at the forefront of anybody who is considering a very sad situation of divorce, after, of course, the best interests of the children, because they come first. So that is something that they need to look at and contemplate. Can I just finish off by saying this, in terms of this particular issue,
yes, of course,
ancillary relief? Going back to an observation that I made earlier on, that not all couples have marriages which are recognized under English law, the law of England and Wales, or this jurisdiction, rather, because their marriage in the marriage was undertaken in accordance with Islamic principles but not registered as a civil union.
Yes.
And moreover, they may not be able to necessarily go down the talata route for whatever reason, if that is the case, if it's a particular property or something else. There may be other avenues as well for them to consider, because there may be a number of promises that were made, a number of different agreements that were made between the parties, and then
there's a condition of dowry as well and all that.
Well, yes, dowry is something else, because with the dowry, the actual nikah contract is effectively a contract recognized under English law. There's a string of case law, a voluminous amount of case law, which confirms that the nikah agreement is recognized under English law. So, for example, if the mahar or whatever it's called by different people, if that is prescribed, then that, for example, if it's deferred and on demand, it needs to be paid. But what I'm saying is over and above that, because those sorts of requirements or prescriptions, rather, are usually quite limited. A few £1,000s or a bit of gold or a combination. And therefore a party may consider, particularly bearing in mind if the marriage or the union, rather, is of any particular length, they may believe that they're entitled to something more, especially if there have been any sort of contractual or any sort of other agreements or understandings between the parties, especially where something has been done to their detriment. So the usual contractual law, the contract law principles come into play, and these are principles which must be borne in mind, because what I've seen, very sadly, is that there are a number of occasions where people have believed that they may not be able to argue an interest that they may otherwise have. And for that reason, they, what we call, take it on the chin, and they walk away. And that is very unfortunate, because people's lives can be miserable. These are not people who wish to unjustly enrich themselves. They simply want to take what is fair. And very often we find the case that not everybody is as principled as they could be or should be. And therefore a position of unfairness arises, as a result of which justice is not served. And the overriding objective of the procedure rules and the court, the legal framework in the United Kingdom, is all about attaining justice. It's all about dispensing justice.
Yes.
And that is why everybody who believes that they may have a particular claim because they have made a contribution, not just necessarily in monetary terms, but other ways as well, they really should take a long, hard look. It doesn't have to be expensive. But not doing so can be very expensive.
Yes.
And that's something that maybe, the general public, particularly those in our communities, who
Yes.
may be the victims of need to take a look
It
at.
is very true that in our community people are not giving much importance to these issues, and the family elders, they sit together and they decide whatever they have to decide, and they don't consider the fate of the victim who may suffer for life. So these are important issues, and proper legal advice should be taken on those, as it has been expressly stated by my learned friend, that your nikah, which may not be considered under the UK immigration law as valid marriage, but under contractual law, you still can use that if it is in your favor, and you can get some relief under that. So it is important to consider having a proper legal advice. So if you have any particular situation like that, you can ask us, info@m-artsolicitors.co.uk. We are very sure there was little disruption as well because of technical issues. I hope everything is smooth and going on. We will share the full video again on Facebook if someone has missed any part, so they can look into that. There are more questions which are more towards immigration. So thank you everybody who's appreciating our live session. There's a question: what is the time period required for Home Office to make a decision on the basis of 7-year application? See, the standard time period Home Office is suggesting is 6 months from the date of biometrics, but it can be more, it can be less. So there is no specific guideline. There are people who are waiting for application for 10 months, for 12 months, or even longer. So it depends on particular application, but standard application should be decided within 6 months from the date of biometrics. So if you are facing a further delay, you need to contact your legal representative so they can advise you further whether this is the right time to contact the Home Office. The other question we have is, I need to apply on the basis of my son who has spent, probably want to say spent 7 years in the UK. Can I go through premium service? If so, what are the charges, and do we have to pay for each applicant or per application? Each applicant has to make each application. So yes, the fee is per application, which means per person, and the fee at the moment for standard is £2,053 if you're making this application. If you're going for premium, then you're considering another £600 to £800 extra. At the moment, premium service is not available, but if the Home Office announces in coming days, then it will be available. So yes, it is per application. You have to pay for that, unfortunately. Another question, I'm here last 11 years. I don't have any legal right in this country. Any chance can I get my legal status in the UK? There are different categories. There is one category for those people who have been in the UK for 20 years or over, legally, illegally, doesn't matter. And there is a category for those people who have been staying in the UK but not for 20 years, less than 20 years, but they can prove to the Home Office they don't have any family ties, any social ties, any economic ties with their country of origin. So on the other hand, they can prove all these ties with the UK. Then case to case basis, they will decide, even though it will be a difficult case, but it's a wrong assumption that the Home Office will not grant status to those people if your case is better, like we have been dealing with so many cases. And I gave you a scenario last time I did mention, and I gave you a tip on that, that if you have a particular skill, particular experience, particular education you have, which is required by UK, you should go through the shortage of occupation list as well. And if it falls under that, I would suggest that you should inform the Home Office, make a proper business plan to show the Home Office that, look, if I have been granted visa to this country, I will be able to open up my own business, establish my own business. I would be able to employ 2, 3, 4, 5 people from UK, and you would be helping the UK economy. So it is up to you how you build up your case. So yes, the answer is you can make an application, but just not make an application on the basis that I'm here for last 11 years. I don't do much. I don't know much. There it is. No, you have to show all these aspects.
May I just get
Yes,
to that
please.
point just before you
Your
move on to
expert
the,
opinion on that.
just before you move on to the next question, because this example you gave just now, the question that was asked by your guest is actually a very important one. It's a very common one, because there are a number of people who have not been able to be to have not been here for 10 years lawfully or 20 years without status, continuously. So what seems to happen is that people are then concerned as to whether or not there are any opportunities or avenues open to them to be able to remain in the United Kingdom. And then, of course, you explained very, very well the discretionary basis on which the Home Office operates and the kind of considerations that the Home Office actually have. What I find in my experience is that when you ask the client or the individual, the subject, the right questions, it then transpires that they do fall into various categories, and they can particularly tick boxes to be able to fall squarely within various provisions of the immigration framework, the legal framework. So, for example, in terms of the long residency, where somebody is unable to meet the 20 years lawful residency or the 20 years unlawful residency or the 10 years lawful residency, you have, for example, paragraph 276 ADE, subsection 6, where if somebody is able to demonstrate, for example, that they will face significant obstacles in returning to their country of origin, then that is something that is prescribed within the rules, without having to look at a circumstance outside of the rules, the Article 8 outside of the rules, for example. They do not need to go that far. So then somebody may be able to demonstrate that whilst they do not fall within the asylum provisions, nevertheless, the circumstances of their case, albeit not within the 1951 Convention and its protocol as we call it, nevertheless, they do fall within provisions which tend to suggest that they would face significant obstacles to re-establishing themselves in their country of origin. And therefore, under paragraph 276 ADE subsection 6, they fall within that provision. And these are the kinds of questions where... And the reason I raised that, and I rudely interrupted you, is because a number of people within our communities say, well, I don't come within a convention reason,
and therefore I cannot claim asylum. So, for example, I'm not a member of a political group, or I don't have a particular religious or ethnicity or social group, and so on and so forth. But there are circumstances which can be elicited from them by asking the right questions, which tend to suggest that yes, there will be significant obstacles, and you know, it will be unduly harsh for them to return to their country of origin, and the Home Office needs to know in order for them to be able to come to the right conclusion as to whether or not this person can. And if I may just labour that a little bit in terms of the 20 years, for example, from my experience, what I've seen is that many people say, well, I've been here for 20 years, but not under my identity because I cannot prove it. I don't have the documentation. Yes, I came 20 years ago or more, but I came and I remained in the United Kingdom under an alias, and all my documents suggest somebody else. But actually it was me. And there are a number of reasons why people use aliases. Now, I'm not condoning that. I'm not encouraging that. But what I am saying is that far from me to say it, the courts have said it. And there is a case which springs to mind, ZH Bangladesh, Zakir Hussain, that particular individual, remained in the United Kingdom, and I think at that time it was 14 years. But the same principles apply because the legislative framework and the case law has been interpreted to mirror the Zakir Hussein's circumstances can be mirrored to the 20-year provisions, where somebody who has resided in the UK, albeit under an alias, so for example, has opened a bank account in somebody else's name, has paid taxes in somebody else's name because they themselves weren't eligible to work using a particular national insurance number or permit or whatever. Nevertheless, the courts have held there that, notwithstanding the fact that it is not to be encouraged, it is a reality, a harsh reality rather, that people do remain in the United Kingdom using whatever means they can. And the very fact that the provisions recognise that somebody who's been here for a length of time, for a particular term, has done so unlawfully and allows them to remain in the United Kingdom after that time has elapsed, that recognises that the activity, the very presence was unlawful, irregular. So therefore, whatever they did would be unlawful. And the courts recognise that. So my appeal to our respective viewers and the wider community and people that they know must be this. Don't be discouraged and disheartened by the fact that even if you are unable to demonstrate that you've been here for 20 years with documentation in your name throughout that particular period, don't give up, because it is entirely possible for you to be able to discharge your burden of proving your residency and ultimately succeeding. These can include, for example, photographs with people. So over the years, you might have photographs of you at different stages, shortly after arrival, now and in between. You can have letters from people that you know, if you visited the local mosque or the temple or the Gurdwara or wherever the case may be. These people may be able to certify that yes, actually this individual comes and prays here. I've known him for so many years. So what I always suggest is that if, for example, they sit down and do a table and have a tabulated format where they can insert what evidence they have. So, for example, listing each year in column A, and then in column B putting down what sort of evidence that they might have for that given year, and if possible even break it down. So, for example, January, February, March, that quarter, this is the evidence available. Quarter 2, this is what's available. Quarter 3 and 4, this is what's available. And even if it's just a piece or two of evidence for each particular category, break it down by quarters or months or whatever the case may be, whatever's possible, then that would assist the Home Office, and even if they find make a decision which is adverse, it would assist the court, the tribunal, in arriving at a fair conclusion as to whether or not it is likely that that individual has been here for 20 years or not. And so, as I was saying, it may well be the case that the documents are not in their name. It may well be the case that the activities that they engaged in were not regulated in the extent that they were not given the proper licenses or the permits to work or whatever else they did. But don't fear. Go and get some legal help. Think about it very carefully. When I say think about it, I mean rack your brains and consider what sort of evidence may be available out there. Because at first at first glance, you may not think that a particular piece of evidence is available. But when you delve into it a little deeper, it may come to light that actually there is somebody who can provide a piece of evidence. Because if you look, for example, and this is a classic case, when somebody puts in, when they're undertaking the exercise of trying to establish 20 years, when somebody's going through that particular period, they can start by saying, well, I first lived at this address, and then I lived at this address, and then I lived at this address, and then break down the rough years. They may not know exactly which month and so on and so forth, but they may know which years roughly. And then they might think, oh, actually, when I was living at that address, there was a neighbour I was quite friendly with, or I used to know the shopkeeper there, or I used to be friends with the chairman of the local...
Used to visit the local park and all that.
Absolutely. So if it may trigger your memory in terms of people that you may know or associate with a particular address that you may have resided with. And then, following further investigation or inquiry or, or even a cold call, it may well be the case that somebody is able to assist. They may provide a document, and they may be able to add that on as part of your bundle of documents to be able to demonstrate that you've been here for 20 years. So, I mean, the immigration framework is complex, but it's not difficult. It's complex to the extent that there are a lot of provisions. The HC 395 is voluminous, and in terms of case law, the case law evolves, as you know, daily, absolutely daily, through not just the first tier and the upper tier, because the first tier is not binding. In fact, the upper tier is not binding, but it's certainly persuasive. But then in the High Court, the judicial reviews, the Court of Appeals, the Supreme Court, in fact, we sometimes get cases which go up to that particular level in the immigration jurisdiction. Those are helpful because they guide what's happening, but there's so much of it. And sometimes one finds that it keeps getting batted about. So in terms of the ETS side,
yes,
the case law keeps going up and down. In terms of the 3225 situation, the cases keep...
Yeah.
Absolutely. The case law keeps evolving on a regular basis.
And now the EU.
Well, absolutely. Yeah. Well, absolutely. That's quite dynamic as well.
So on a monthly basis, actually.
Yeah, absolutely. And I mean, in terms of 3225, you have the core case of Balajagiri, but then there are also other cases which actually... guide how a particular case must be presented. So there is a lot of it there, but it's not difficult. It is voluminous, but it's not difficult. And that is why it is necessary to set out facts rather than just taking a hunch as to, well, I've been here for 20 years, but I can't prove it. Well, nothing I can do. Or I've been here for 10 or 11 years, but I haven't been lawful, and therefore, because I don't come within, the long residence requirements, that's game, set, and match. Well, no, it's not. And it would be very unfortunate if people who are in the United Kingdom, who are subject to immigration control, who have not been able to, for whatever reason, regularize their stay, because they may have entered lawfully, they may have come as a spouse, they may have had that relationship break down, a spouse may have withdrawn their sponsorship, they might find themselves in no man's land, so to speak. That is not uncommon. There are a number of people here who have come to the United Kingdom quite lawfully, quite properly, on an employment migration scheme perhaps, or a student basis, for example, and then they've found that their academic institution is not quite what they thought it was, and therefore that institution has had their license revoked or something has gone on. And so essentially what I'm saying is that people should not think that others whose immigration status is precarious, as we call it, and moreover others who are irregularly here in the United Kingdom. I hesitate. I don't like using the word illegally here because no human being is an illegal person. It's an unlawful status that they might have to the extent that it may not be regularized. Nevertheless, there are ways that people can seek to better themselves and seek to regularize themselves in the United Kingdom, because everybody out there who is living precariously or without formal status, regularized status, doesn't want to live like that. They want to be regular. They want to pay their taxes. They want to live lawfully. They are, by and large, law-abiding citizens. And they do not want to be a burden on the state, if anything, because they don't want to make claims, because, as we know, there's a lot of stereotyping that goes on, a lot of finger pointing that takes place, where people say that these people are here just to scrounge off the state, and so on and so forth. Well, no, that does not apply to the vast contingent, I dare say, of migrants in the United Kingdom who are here without status. They do, as I say, they want to work, they want to pay their taxes, they want to get on, they want to speak English. Again, another slur that's levied at members of the communities, that they don't want to interact and integrate. Well, yes, they do want to interact. They do want to learn English. They do want to engage with society. They don't want to be aliens, or they don't want to be pariahs. They do want to be part and parcel and play an instrumental part in taking this country into the 21st century. And that is why the avenues are there. They need to come to people like you to be able to signpost them on to what sort of provisions are in place to be able to regularize their stay. And inshallah, hopefully, they'll find some joy.
Thank you very much. Once again, Barrister Rehman Mian has given you a very detailed, full-length information in relation to immigration as well as other areas. And the moral of the information is that if you don't ask, you don't get. And it's also the saying is that not knowing is bad, but not wish to know is even worse. So you need to contact the legal representatives. You need to know all the avenues, what you can do, what are your circumstances. We call it full and frank disclosure with your legal representatives, so they can put you on the right track and they can guide you how to move forward. Our live session has gone a little over, but I believe you have grasped all this information. But if you have any particular question in relation to immigration, non-immigration, litigation, any matter, you can send us an email on info@m-rsolicitors.co.uk. There are a couple of questions which we haven't answered, but we will do that on the messages to your inbox, and you can still email us. If you want to make an appointment, the number is 0208-518-1956. Thank you very much, Anwar. It was really a pleasure, and a lot of information we have gained from you, and it was practical actually. The thing is that we do get information, but it's not practical. So the information you have shared with us, it's useful, and common problems our community facing. So I appreciate that you took your time.
Thank you very much for allowing me to come and share the platform with you, and thank you very much to our guests for taking the time out to watch.
Well, with this saying, I say bye, that if your actions inspires others to dream more, to learn more, to do more, to become more, then you are a leader. So keep inspiring people positively. Until next session, thank you. Bye-bye.